Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a very important book on commercial injunctions written by Stephen G. Queen's Counsel. This book has come to us from Sweet Maxwell and THOMSON REUTERS. It's now in a 6th edition and it's a very important work. It's primarily, in my view, partly an academic work to a certain extent, but I think it will be of great help to practitioners also. The title that Elizabeth and I have given our review is, taking a little quote, "Because we're a small island, commercial injunctions explained in this definitive work of reference, now in a 6th edition from Sweet and Maxwell." Let's have a look at the book first of all. The review will be on the web and in the journals. It's a heavy book. It's a red cover. There's the front of it. There's the side. There's nothing on the back. Just turn to the back of it. It runs to just over 1,000 pages. The index itself is by paragraph numbering and very much the house style of Sweet and Maxwell. So you've got a very detailed index. You can see how big it is from that. There's the front of the index there. Then you've got at the back precedents, which again extremely helpful. You can see, if I go into the main body copy of the book, you've got reference paragraph numbering at the side and footnoting. It's a very substantial work, very much a work of reference, but I think of great help to anybody involved in this area of law. Now at the front we've got the front page, which I shall just get to. There we go. See the little front page there. Then there's some information there concerning the book, and then there's a preface to the 6th edition. Do read the preface because it'll tell you what's new and what Mr. G has introduced into it. He mentioned Salomon and Salomon, and that's a long time ago. He actually wrote the preface in April 2016, and I'm recording this in the autumn. But he does set out some of the most useful, quite recent case law. Then there's some acknowledgements which he puts in. Then you can see he's actually dedicated it to his wife. The dedication's a little hidden, but I'm going to put that in because I like people to know the book is dedicated to, because there's a huge amount of work that goes into these books. We only review books that we think are important. We don't review books that are ones where I want to make highly critical comments of them, because I know how much work goes into writing a book. David Neuberger has written the actual foreword, and then there's Leonard Hoffman has written the previous foreword. And then we've got various other forewords, which I'm not going to go into because you can read them yourselves. Table of contents. It's quite detailed, the table of contents, and I think you'll find it helpful. You should be able to find what you're looking for quite easily through either the contents section or the index. There are 25 chapters in total and a couple of appendices at the back, which you can see. And certainly the book itself has a vast array of cases. You can see those listed, a large number of cases throughout. I don't know how many pages in total, but those are just the UK ones. Then we have the USA cases again, and then we have statutes. See, there's a lot of background information contained. CPR rules listed as well, and then we get into the book itself. This is Chapter 1, The Evolution of Injunctions, and Anton Pillar Relief, which is what I used to know them as, Moravas and so forth, when I did my bar exams, which is a long time ago now. What is an injunction? And he goes back into history. Justice Story, in his commentaries on equity jurisprudence, described a writ of injunction as a judicial process whereby a party is required to do a particular thing, according to the exigencies of the writ. That's a long time ago. I'm looking at the date. 1867, round about that sort of time, so very, very Victorian. Now, the book itself, you can see, again, the structure. Paragraph numbers at the side, and footnotes, and the paragraph numberings are how you find things from the index at the back. Now, what do we say about the book? Because injunctions you hear about them in court, certainly hear about them on television on a regular basis. They have different names, but they all basically mean the same thing. That is, you're told to do something, you're told not to do something. And it's a promise, if it's in terms of something like a non-molestation order, or it's actually, and that's a promise to the court, of course, in something like that, or because it's called injunctive relief, or it can be all sorts of other things. It's promising not to libel someone, all sorts of things. So what do we say then? Well, to say that this book is a successful legal text is something of an understatement. As the 6th and latest edition from Sweet Maxwell attests, this highly regarded work of reference on commercial injunctions, and these are commercial injunctions we're talking about, has a publishing pedigree that goes back about 35 years, during which time it's become an established authority cited in the courts in England and Wales as well as internationally. And I'm going to say something here which I think is very important, and that is that these books are where the law is. And we rely on this information. It's published by people who are in the commercial sphere, they're making a profit. But this is where the law is actually found, and this is of great benefit to practitioners, that's lawyers, judges, academics, researchers, anyone involved. And it makes our lives a lot easier because it gives us some way of understanding where we're going with a particular knotty little problem that we might have, which needs adjudication. Now, that is why these books are so important. And people often say to me, well, where is the law? Well, it's in these books. That's where it is. It's obviously procedural as well, but it tells you how to do things, and that's the basis of it. It also looks at some of the jurisprudential issues that can arise where there's a very substantial controversy, with one view being taken by one group of people, another view by another, and then you've got to try and find out which side that where you make your decision. So you see how important they are. Anyone who needs to know anything about commercial injunctions, says Lord Neuberger in the foreword, will find this book invaluable. In the complex and fast developing area of commercial law, he adds, it's important to have a comprehensive, up-to-date, authoritative, well-structured and readable book on the topic of commercial injunctions, and that's what you get here. He further points out that the development of commercial injunctions has evolved in response to the need to provide a practical service for the commercial community, and refers to the consistent determination of the judiciary and lawyers of this country to ensure that the courts maintain a realistic and sensitive attitude to the development of commercial law. Very important point, because the problem of the injunction, as we have seen in terms of global policy, can have difficult consequences. One obvious reason, stemming from what David Neuberger says, and this is rather topical, is the importance of international trade to the inhabitants of a relatively small island. Another very relevant point here is that over 75% of litigants in the commercial court in the Rolls Building are not UK nationals. Of course, we are very much a centre for dispute resolution through the courts. Obviously, Singapore is a popular area too. Now, as the term injunction is used, so often referred to in the press of late, as I've said before, it tends to defy precise definition. So the author, Stephen G., Queen's Counsel, refers to the civil procedure rules. Quite a good idea, I think, which include a glossary or guide to word meanings in which injunction is described as a court order prohibiting a person from doing something or requiring a person to do something. That has always been the basic definition I have used as a law tutor when I have explained what an injunction is to students. And I think that's the best simple definition, working definition we can have. This, says the author, is not a definition. So he's just ruined what I've just said. But the point is that it gives you an idea of what the concept is. Explaining that the meaning of the word, like all other words, depends on its context. We can also use in court injunctive relief, which of course is how I put it to the clients. As you would imagine, this point is elaborated upon extensively We are lawyers after all, so we're going to argue about things. But however you define or you don't define an injunction, it can be a frightening thing if you happen to be the recipient of one. And in this context, the area of law becomes specific to corporate lawyers, all of whom must be aware that it can be excruciatingly complicated. And it is. It's a problem. But this is where the book, I think, helps, because I found when I first studied this, and in fact it was mainly at the bar school, I found it really complicated to understand, and I would have liked something like this book with the refreshing way it's set out to help me understand Moravers and Anton Pillars a bit better. Now, this book, therefore, having just sort of given the general statement of it, says it is, in addition for all of us, a valuable statement of an explanation of the position regarding commercial injunctions at this time. That's 2016. We've been through a very substantial change with civil procedure, and we therefore have come out of it using new words. It covers, of course, this book, the evolution of injunctions by way of introduction, and it deals notably with the Anton Pillar relief and the Moraver relief, which of course we used slightly different words for now, but we still call them that, as well as a host of other matters, including anti-suit injunctions, the without prejudice rule, and the duty to make full and fair disclosure in the serious matter of contempt of court, all of which are, frankly, when you're dealing with a client, a problem area, because clients quite often don't really understand that side of it, and so it's a matter of explaining it to them. And I think this book also helps us as practitioners understand where we are. Let me conclude by saying that suffice to say that the book covers this fast-moving, ever-changing area of law with admirable clarity, and it also contains a wealth of research resources, including extensive footnoting, tables of statutes, cases, SIs, civil procedurals, and US cases as well, which I thought was very helpful. And for ease of use, paragraphs are numbered throughout, as I've said, and there's a detailed table of contents and an index, so you should find things quite easily. No international corporate law, in our view, should be without this definitive work of reference, and the publication date is cited at 2016. I'm recording this in the autumn of 2016. It's a very important book, this one. There it is again. We must thank Sweet and Maxwell, as I've done before, for producing these works, because they take the mantle on, because there's not a large number of copies of these books are sold, but they're very important. That's an example, there's a footnote, there's the referencing, the actual paragraph numbering, and then the footnoting at the bottom. And you can see this is on misrepresentation. Injunction restraining bank from making payment. Very important area, can quite possibly lead to insolvency. Conflicting duties, lots of information there again. Refusal to hear a party in contempt. So there's a huge amount of information in the 1,000-odd pages. Orders against non-parties leading to disclosure. Release of a restriction. This is very much, although what we call civil litigation is a very wide area, this covers the very, very major, in fact the backbone, if you like, of a lot of the civil litigation matters that you need to know of, certainly as a junior barrister and as a student, apart from anything else. Because what it's doing is it's looking at where we are, but it's also looking at all the issues. And this is an area that a lot of people do not understand at all, but think they understand. And that's where the problem can be. I mean, obviously the greatest book is the White Book, which I think is a superb work, which sets out what we do. But these books as well are great. Mr. Stephen G, thank you very much indeed for what you've done. All the other people involved, the contributors, it's a massive work and very, very helpful to all of us. Thank you. Bye-bye.